As usual, the police IG and his stooges came to court today to waste our time, taxpayers' money, and to embark on frivolities and waste of treasure taxpayers' money. In continuation of the charade that they've started against Mr. Sowore since 1989, they filed a 3-count amended charge accusing Mr. Sowore of publishing a police wireless report. But principally, the major grounds of the police IG was the protests that Mr. Sowore and some retired police officers held in demanding for better welfare for the Nigerian police force. They also accused him of making publications about, in quotes, the mistress of the IG. There were 3-count charges filed by officers and lawyers in the office of the IG. We have informed them that those charges are incompetent. The charges are unlawful, and they are just mere attempts at wasting our time, their time, and more importantly, taxpayers' money on frivolities. We filed an objection where we have informed the police IG that the police IG has no power under the Police Act of 2020 to use his office to fight for personal vendetta. The petitioner, the nominal complainant in this 3-count charge that we came to court for today is Yemisi Kuti, the alleged mistress of the police IG. She is a principal staff to the IG and an officer in the Nigerian police force. The Police Act clearly forbids any police officer serving or retired from using the instrumentalities of the office of the police force to fight for personal vendetta and as a means of settling personal score. The instant charge today is an example of such an abuse of prosecutorial powers. Section 174 sub 3 of the Constitution stipulates that any charge to be filed in court must be in compliance with equity and the interest of justice. This particular requirement of Section 174.3 is lacking in the charge that was filed by the IG. This is a clear attempt at scuttling and shrinking the civic space in Nigeria. We join Nigerians all over the world to condemn this instant charge as a misfit, as a misuse, as an abuse of power, and we have asked the court to quash the charge. There is even no need by a plethora of authorities decided by Nigerian Supreme Court. There is no basis for entering a plea in a defective charge as what we have in court today. And we have informed the court that we are not going to take any plea on this inherently defective charge. These charges, as they are presently constituted, must be quashed. The court must throw away the charge without wasting further the Nigerian taxpayers' money. And we have also enjoined the judge because the police regulations and acts, which is the Bible of the Nigerian police force and its officers today, clearly prohibits and recommends that an officer who uses the instrumentalities of his office to pursue and prosecute personal grievances, that such an officer must be recommended to the appropriate authority for sanction, because such an act is an act of indiscipline that violates the police code. So we are urging the court to mandate the lawyer of the police force, who is also a police officer, to recommend to the appropriate authority, to recommend that both Fola Kuti, Yemisi Kuti, the IG, and other officers in the police force who have abused these particular provisions that we have accentuated in the charge, that such officers must be recommended for appropriate disciplinary actions. This is what we're asking the court, and this is what the law requires of His Lordship. We thank you, Lordship.